Good morning. Today we're going to talk about the Puerto Rico Public Corporations Debt Enforcement Act, an act that was passed in June 28, 2014, that's been nicknamed, Spanish acronym, La Quiebra Criolla. Less than 24 hours after La Quiebra Criolla was enacted into law by the governor of Puerto Rico, two funds, Oppenheimer and Franklin, mutual funds with about over $2 billion in debt or bonds, filed a suit, a litigation in federal court, District of Puerto Rico. And later on, Blue Mountain Capital joined the suit. They're different, although they're different litigations, they both were consolidated by Judge Francisco Besosa from the District Court of Puerto Rico, Federal District Court. They both seek a declaratory judgment to declare unconstitutional the law, the act, the Recovery Act, as it's been called also, and to void the act under constitutional provisions. As we've said before, this act is modeled or mirrors Chapter 9 and 11, supposed to be modeled after that, but lacks the creditor protections under 1129B of Chapter 11. So they're not identical, and we will explain them a little bit more before we get into the litigation. The act themselves were passed as part of a response by the government of Puerto Rico to the fiscal crisis, the fiscal emergency of Puerto Rico. We've had about over 6 years of negative growth on the island, unemployment over 15%, budget defaults, and basically a series of governments for the last 10 years that are using floating debt to pay current operations, which has been criticized. The agencies targeted by the Recovery Act are basically four. Doesn't cover all of the government of Puerto Rico, but these public agencies, the power of the water, the transportation, and ports, PREPA, PRASA, ports, and highways, basically. These four agencies owe over $20 billion out of the Commonwealth of Puerto Rico total government debt of about $71 billion as of 2014. The deficit of at least three of these companies, PREPA, PRASA, and Highways, is in excess of $800 million in 2013. PREPA alone had a debt of $9.6 billion and also short-term bank debt. It owed to three different banks of about $500 million when this law was passed back in June 28, 2014. The government of Puerto Rico passed this act, the Recovery Act, alleging that there was a gap, that Puerto Rico had been excluded from Chapter 9, which deals with municipal entities, filing of bankruptcy in municipal entities under 11 U.S.C., the bankruptcy law of the U.S., and that Puerto Rico was not considered a state for purposes of the definition of who can be a debtor under Chapter 9. So based on the fact that there was no legislation in Puerto Rico and there was no legislation under the federal bankruptcy court or in the U.S., the government of Puerto Rico thought it was proper to legislate and cover this field, which had not been covered, they said, and now we know differently, by U.S. Congress. Also, most experts think that Chapter 11 cannot apply to agencies like PREPA, like PRASA. These are public utilities, monopolies of the government of Puerto Rico. Other people think that they are eligible for Chapter 11, the traditional Chapter 11, as any business, because they have board of directors, separate board of directors. They're appointed separately. They have independence of judgment, and they issue their own bonds. There's some litigation in circuit courts and in the District of Puerto Rico that have held under the immunity clauses, also that they're considered more like private agencies, and maybe a possibility would be to file a Chapter 11 for one of these agencies like PREPA. The government of Puerto Rico also argued in their defense of the litigation brought by Oppenheimer and Franklin that there was nothing in the Puerto Rico legal system that allows restructuring of debt. And there being nothing in the U.S. system or no law in the Puerto Rico system, there was a gap that they were allowed to fill because Congress had not legislated regarding restructuring of the territorial debts of Puerto Rico. By the way, what this brought about when this law was passed, because it was passed without public hearings, it was passed overnight, and it was effective immediately. There was a lack of transparency, lack of consultation with any of the bondholders in Wall Street. So it brought a lot of bad publicity to Puerto Rico, and the rating agencies stepped in right away, Standard & Poor's and the rest, and devalued PREPA to junk status, and also brought down all the other Puerto Rico obligations, including the COFINAS, which are earmarked bonds from sales taxes, and GDB, which have special protection, and even the GOs, which have constitutional good faith and credit from the government of Puerto Rico, and are not covered by the new act, by the Recovery Act, by the way. They even devalued these other bonds of the government of Puerto Rico to the big surprise of the government of Puerto Rico. So they were taken by surprise by the reaction of Wall Street and the rating agencies. As we were saying, after the law was passed, the Recovery Act was passed, which, by the way, is Act number 71 of 2014, the banks and the bondholders got together. And of course, after the devaluation by the rating agencies of all the obligations of the government of Puerto Rico and its agencies, the banks and bondholders got together and decided to negotiate with PREPA. They came to an agreement for a moratorium, and which is still going in effect. In March of 2015, there should be a report in. There's been an appointment of an overseer. So, and there's been a forbearance agreement signed with banks and bondholders. So the agency is in the process of restructuring. But going back to the act itself, it's important to mention who is eligible and what kind of an act is it? Is it a bankruptcy act or is it a composition? How can we name this beast of the Recovery Act, Quiebra Criolla in Puerto Rico? First of all, the exclusions in this act are very numerous. It excludes GDBs, Government Development Bank. It excludes the government obligations, general government obligations. It excludes the COFINAS, University of Puerto Rico, and all the municipalities. There are 74 municipalities. Most of them issue bonds in Puerto Rico. And basically, this act was addressed to 4 agencies, which I mentioned before: the power, the water, the transportation, highways, and ports. How does it work? Well, the Act has the first section of the Act, the first part of the Act deals with general matters, just like Chapter 3 and 5 of the U.S. Bankruptcy Court. But the Chapter 2 is a consensual debt modification part, and Chapter 3 is a court-supervised restructuring process, which is more like a Chapter 11 under the Bankruptcy Code. How does the consensual part operate? This is a court-supervised process. It could modify, it's used to modify interest rates, maturity, and extend terms of loans. It requires a recovery program be adopted under the court authority, and it can affect debt. It has an automatic stay, just like Section 366 of the Bankruptcy Code, although it's really suspension period, it's called, not automatic stay. And it's for 270 days, which may be extended. There's no actual filing under Chapter 2 of the new law. It's triggered by basically posting on the webpage the intent to effect one or more creditors or a group of creditors by the specific agency. And there is an obligation on the part of the agency to negotiate with affected creditors and to submit a recovery plan in good faith. There are voting requirements to accept and basically cram down the dissenting creditors. As a 50% of debt entitled to vote must participate, and 75% of those must be in favor. So there are some safeguards for dissenting creditors like you have in a normal Chapter 11 reorganization case. There's court confirmation or court approval of the plan, and once a plan is approved, it binds all creditors. Now, Chapter 3 is not a voluntary program like we just described in Chapter 2. Chapter 3 doesn't call for consensual approval, but rather it's a judicial restructuring. Court-supervised judicial restructuring is the way the Act reads. And instead of a plan to be confirmed, it's an enforcement plan, and there is an actual filing of a petition like a Chapter 11, contrary to Chapter 2, which I said you just have to post on the web page that you intend to use the chapter. There is an automatic stay on all affected creditors that are listed, so all actions against the agency are stopped by the mere filing of the petition, just like in bankruptcy, U.S. Bankruptcy Code. There is a debtor in possession concept. In other words, the agency continues operating from day to day once the case is filed. And there is a liquidation value test similar to the best interest test in Chapter 11, but a little different in language, more lax. Only one class is required to vote to accept, and that binds creditors. And you have also the voting requirements of majority in class and 2/3 of affected creditors to bind minority creditors to the plan that's being approved, not confirmed again. So there is a cram down, permits a cram down of not consenting creditors as in a Chapter 11, but without all the 1129B protections that you would find in a normal Chapter 11 case in a private company. This has, of course, been one of the arguments against the law, that it goes too far. It modifies obligations without protecting creditors, and I think it was behind a decision that we'll talk about a little later today, issued by Judge Francisco Besosa of the U.S. District Court of Puerto Rico, actually voiding this act on constitutional grounds. So the suit by Franking and Oppenheimer and Blue Mountain Capital that followed is a declaratory judgment, a request for a declaratory judgment, and a request to hold by the court to hold that the act violates the U.S. Constitution, the bankruptcy clause, uniformity of bankruptcy clause in Article 1, Paragraph 8. It also, they claim, violates the takings clause, and it violates the impairment of contracts, prohibition of impairment of contracts in Article 110 of the U.S. Constitution. One of the issues that was really controversial in this case, and was the defense of the Puerto Rico government, defended this litigation against the three funds, is that the matter was not ripe for adjudication. Under Article 3, there was no case in controversy under Article 3 of the Constitution, is what the government of Puerto Rico argued. Some of the special revenue bond holders also alleged that there's discrimination because they were not excluded specifically from the coverage of the act, like the general obligations and GDB, the Government Development Bank bonds, and that they're being singled out for impairment, contrary to others that were specifically included. This argument was not brought out in the court, but it's something that's been argued by this group of bondholders. Now, the Besosa opinion came out on February 6, 2015. It was very fast. Judge Besosa acted promptly. There were 3 motions to dismiss and cross motions for summary judgment, so he had to decide them all. Basically, he held on most of the issues in favor of the government of Puerto Rico. He held that the supremacy clause of the U.S. Constitution is violated by the act, that the act is void. He held also that the field is preempted, and he went as far as to issue a permanent injunction against the government of Puerto Rico to be enjoined from enforcing the act in the future. What does Besosa use? What does he refer to base his opinion? Judge Besosa, first of all, he cites the PREPA, Puerto Rico Power Authority, we call it PREPA, the initials, the Enabling Act, which goes back to 1941, which gives the bondholders a series of rights. He also cites the trust agreement as amended. The original trust agreement cited goes back to 1974. And he cites, of course, the Recovery Act itself of 2014. And finally, the fourth item that he uses to reach his conclusions that the Supremacy Clause has been violated and that there is preemption of the federal government in this field, that the act is void, is that Chapter 9 of the U.S. Bankruptcy Code, in various sections, 101.52 and 903.1, covered and filled basically the area of composition of debts in the territory of Puerto Rico, that there is no gap, that Congress acted under 101.52 of 11 U.S.C. and 903.1 of 11 U.S.C., and that is why the Supremacy Clause is activated, is triggered in a situation like this. What does the Enabling Act actually say? What are those rights that Judge Besosa held that had been violated? Well, the Enabling Act of 1941 for PREPA, we're just talking about PREPA because PREPA was the only defendant that was brought in this suit. No other agency was brought in. And actually, PREPA was dismissed by the judge. That's one of the few issues that were won by the government of Puerto Rico. But what the Enabling Act of PREPA says is that the bondholders' rights will not be altered, amended, or limited until all the bonds are finally paid. It also gives the creditors, the bondholder, the right to appoint a receiver if there is a default in any of the sections of the bond agreement. It creates a series of superior liens in case of default against the income flows of the agency. And it says that a default also occurs if PREPA seeks a composition of debt, a restructuring of debt, or adjustment by law or by amendments to their acts in the present or in the future. So if any of these things happen, if these rights are violated, what are the remedies that a bondholder has for a default on any of the above? Well, first of all, the Enabling Act says that they can accelerate payments of bonds. The maturity date can be accelerated. Or B, they can seek the appointment of a receiver, which creates a series of issues. Where do you seek the appointment of a receiver? In a federal court, in a local court, in a court in New York, in a court in Puerto Rico? Those are issues that haven't really, these are issues of first impression that haven't been decided and were not decided by Judge Besosa. And what law applies to this receivership? Is it the Puerto Rico law, the old Spanish codes that we have in Puerto Rico under the civil and commercial law, or is it some kind of common law receivership process? And the third issue, or the third thing that bondholders can do if there is a default in the Enabling Act of 1941 is sue to enforce the terms of the agreement. Again, it's the same issues. Where do you sue? What law applies to the suit? So you have to really look at the Enabling Act of the agency that files under Chapter 2, and then you have to go to the bond instrument itself, so the bond contracts, and see if there is anything about venue, jurisdiction, because these bond instruments vary according to each agency, and even within the agency, they're amended with different issues of stock, so they could be very different. But the court, Besosa does go ahead and say, okay, these are the 4 documents I have to look at to decide whether there's been a violation of the supremacy clause of the Constitution, whether the matter has been preempted. But he also recognizes that there's been a valid fiscal emergency declaration by the government of Puerto Rico and by the legislature of Puerto Rico in the law, in the Recovery Act. And the court goes on to say that the issues it has to address are under Article 1(8) of the Constitution, whether this article, which calls for uniformity of bankruptcy laws throughout the nation, whether this is a basis for preemption, or whether it should preempt under Section 903 of Chapter 9 of 11 U.S.C., which is a separate issue. So it's either preempted under the Constitution, the uniformity clause of the Constitution, 1-8, or it's preempted under 11 U.S.C. Bankruptcy Code, Section 903(1). The court also says, aside from preemption and supremacy issues, that it has to go into the contract clause. Is there an impairment of obligations under the enabling acts that constitutes a violation of the contract clause, impairment of contract prohibition in Article 110 of the Constitution? And thirdly, he says, I have to decide if there is a takings issue. Is there a taking without due process because the bondholders have a right to seek the appointment of a receiver, and there's also an additional lien on revenue. And finally, he says, the 4th issue I have to decide, aside from contract clause, preemption, takings, he says, I have to decide whether the stay that this law under Chapter 2 and 3 of the law, the automatic stay, which the law says applies to all proceedings, whether it stops federal court proceedings, and whether that is a cause for holding that the act violates the Constitution. So the stay of federal proceedings is a 4th issue that he concentrates on. Of course, the government of Puerto Rico comes back and says, wait a minute, you may have arguments dealing with the supremacy clause, but there are issues here of rightness. Article 3, is the case ripe for adjudication? Is there a case in controversy under Article 3 of the Constitution? And rightness, basically, the court says, hinges on whether not only Article 3 issues case in controversy, but it also did the government of Puerto Rico act in a prudent manner, whether prudential considerations. And basically what the rightness doctrine establishes is that you don't want courts to issue advisory opinions on hypothetical questions, and the issue is whether, because there was no actual filing under Chapter 2 or Chapter 3 of the Recovery Act of Puerto Rico, Act 71, whether the issue was not ripe for adjudication. Now, how does Judge Besosa arrive at the issue that the case is ripe? Because that's what he decided, it was ripe for adjudication. Or he goes down the list, he says, is the case fit, quote unquote, for adjudication? Is there a hardship to the parties? If he decides to withhold consideration, those are the questions he asks himself. And is there a direct impact by the mere enactment of an act? Does it cause a direct impact? Because the act, like I said, has not been used by any agency yet. And what does he conclude? He concludes, yes, that it's ripe, yes, that it's fit, and yes, that there is a sufficient hardship to the bondholders of the 3 bond funds that filed as plaintiffs in this case, and that there is an impact. What is the impact? He says, well, it alters the rights under the Enabling Act, which we mentioned before. It alters the right to seek the appointment of a receiver. It stops the creation of liens on income if default occurs. It stops the right of the bondholders to accelerate payments if a default occurs. And also the Enabling Act says that PREPA cannot be amended. The laws creating PREPA cannot be amended to create a composition of debt mechanism, and this act is a composition of debt mechanism, even though the government of Puerto Rico was very careful in drafting it and said many, many times that it wasn't a bankruptcy act. It was it was really an act to reconstruct the finances of the companies and the operations of the companies. So the court basically says, yes, the rights have been impaired by the mere enactment. It doesn't take an act of filing under Chapter 2 or 3. The mere enactment, the signature of the governor is enough, and these creditors' rights have been affected sufficiently. The court also concludes on preemption, which is a controversial issue, that 9031 of the U.S. Bankruptcy Code is a preemption action taken that preempts the Recovery Act. It's a preemption action taken by Congress sufficient to preempt the Recovery Act under the Supremacy Clause, that the Congress has acted directly in this field, and hence the act is unconstitutional. But he also goes a little bit further. He could have stopped right there. He didn't have to go any, but he did. He went as far as 75 pages long as his decision, and he went into the contract clause issue, where he balanced the rights of state sovereign powers, welfare, police powers, retained powers, against the principle that you can't impair contracts in the Constitution, and he decided in favor, of course, of impairment of contracts and against the sovereign powers of the state. He went down the list again of the Enabling Act rights that have been violated by the enactment of this act, and it was very emphatic about the extension of maturity dates, the default provisions, the liens, and also mentioned the fact that 10% of debt holders under the Enabling Act can request a rate increase, and this can't be impaired and is being impaired by the enactment of this act. He also was very emphatic about the fact that this act violates the receivership, the right to appoint a receiver that the Bondholders Act have under the bond instruments, the bond contracts, and the Enabling Act of 1941. The bond instrument was issued originally in 1971. The court goes into the issue, which he may have overextended again himself and may be subject of appeal. Was this act reasonable and necessary? Did the government of Puerto Rico act in a prudential manner? That they have to pass an act like this? Could they have? Are there other measures? And he says yes, they could have done other things short of passing an act that would violate the rights of the bondholders. And he mentions them. Goes down the list. Incredibly, he gives them. He tells you could have cut costs. You could have raised the rates on the utilities, which hasn't been done since 1989, he says. You could have collected $640 million owed by the government of Puerto Rico to PREPA. You could have reduced the subsidies that you have at PREPA right now, and you could cut costs and inefficient management. So he gets into a lot of these items, and finally he says that the government of Puerto Rico could have negotiated voluntarily with to reduce debt, to modify debt, to modify interest rates, to modify the payment terms of these debts, and that no attempt was done to do this. So he's highly critical, the judge, of what the motives that the government of Puerto Rico had to pass this act. Now, we come to the point now we have to, the question is, has anything been accomplished by the government of Puerto Rico by passage of this law? We don't have to go into a crystal ball situation. We have the Judge Besosa's opinion in detail, in great detail, maybe too much detail. And what has been accomplished by the government? First of all, technically they got PREPA dismissed from the suit. PREPA was not a proper party because no case had been filed yet. So on that point, they won on the ripeness and standing arguments to sue PREPA. But most of the other arguments, like I said before, of plaintiff were upheld by Judge Pessoa. His main conclusion, Recovery Act is preempted by the Supremacy Clause. Any issues that permanent injunction forever. Question is, did the court have to go so far? By going so far, is the court opening itself up to an appeal? The answer is yes. The appeal has already been announced by the government of Puerto Rico. He did not have to go into all these other findings once he arrived at the conclusion that the Supremacy Clause was violated by Article 1.8. The fact that there is a uniformity of bankruptcy law requirement in the Constitution under 1.8, that's all you had to really say. He didn't have to cover all the other points and cross all the T's and I's. And he may get into trouble on appeal because he did go into all these other issues. Or he could have said on the favor, I'm going to favor the government of Puerto Rico and say this is not ripe for adjudication. There is no case in controversy. But no, he took that one off the ripeness issue. He took off the table in a very lengthy part of the opinion. The next question that comes up is, will the appeal, the appeal is going to be taken by the government, we know that. Will it get any place? Is there any chance that the appeal and what parts of this decision have a better chance of being revoked or remanded to Judge Pessoa, which is something every judge hates to see, a remand of a case like this. Well, I think that the 901 arguments and the ripeness issues are the best bet for the Puerto Rico government, and they probably will concentrate on those two. The Supremacy Clause, based on Article 1.8, is a pretty strong argument, I think, and that's all the judge had to decide. The issue about Chapter 9 exclusion and inclusion is an interesting point. The court held that under Section 903 of Chapter 9, that this section applied to the government of Puerto Rico, even though Section 10152, the definitions sections of the Bankruptcy Code, excludes the government agencies from the definition of a state. For purposes of Chapter 9, of course. So here you are, Judge Pessoa is saying Chapter 9 doesn't apply to Puerto Rico, you're excluded, but Section 903 of Chapter 9 applies to you, so you can't, so the field is occupied, he says, on that basis. So you're not excluded under 903 of the Act, which limits the powers of the police power to pass restructuring only if it has a consent of bondholders. But it does apply to preempt Puerto Rico, he says, from passing its own laws. And that's where maybe the appeals court will concentrate on the ripeness and the 903 application and 10152 application and the decision that was written by Judge Pessoa. Other questions that come up is, why has Puerto Rico been left out of Chapter 9? Because we have an act in Congress that's been presented to Congress to amend Chapter 9 of the Bankruptcy Code to allow the Puerto Rico municipal entities and government entities, not the states. The states can't file no Chapter 9, but entities, municipalities, and municipal entities can file. Why has Puerto Rico been left out? Why this discriminatory treatment against Puerto Rico, and by the way, against the District of Columbia? Both are mentioned by name in this exclusion. Why can't this territory of Puerto Rico file under Chapter 9 like Detroit has, like Jefferson County in Alabama has, like counties in California, Pennsylvania, Rhode Island, all have filed, Detroit is the last example, under Chapter 9, and gotten relief been able to modify the conditions of at least not so much of the principle of the notes, but at least modify the repayment plans on some of these notes. But maybe the answer is, and I don't think anybody really knows, there's nothing in the legislative history of Chapter 9 and 101-52 that says why Puerto Rico has been left out, but you can surmise that maybe because Puerto Rico has a triple tax exemption, which has been so profitable to bondholders in the past, that maybe that's the reason why they decided not to give Puerto Rico treatment under Chapter 9. Maybe it's just a form of discrimination. Maybe it was a distrust of the people running the territory of Puerto Rico and the thought that they may not give bondholders from other parts of the U.S. The same rights that they would give the local utilities. In any event, we have now a bill presented in Congress to amend U.S. Code 11 U.S.C. Chapter 9, and in a way, the best source's opinion may trigger some action from Congress. There's been other talk by people that the Fed can regulate government entities in Puerto Rico or in any other state and establish a form of a receivership. So the federal government could intervene, is what some people have said, and there could be some intervention aside from Congress, but the executive could intervene and try to regulate and stop an insolvency and in a territory like Puerto Rico. The other question that's been discussed is, can the U.S. courts establish a monitor sort of figure to restructure debt in Puerto Rico? Another question that comes up is, can the Puerto Rico pass a law to create some sort of a mechanism for mediation, negotiation on a voluntary basis that doesn't violate the principles that have been spelled out so carefully by Judge Pesosa, that wouldn't preempt under Chapter 9031, wouldn't preempt this act under the Constitution. Then the question comes up, there's negotiation going on right now between PREPA and the bondholders and the banks that have been lending short-term to PREPA. And how do you organize negotiation? Because there's no question now that the government of Puerto Rico can't repay $71 billion in debt. They just don't have the funds to repay. So it's a question of time that one or more of these agencies are going to declare a default. And technically, PREPA has declared a default already because it failed to pay last year the bondholders and the debts it had to the banks. But there was a moratorium and there was a forbearance agreement, which is in process right now, and it'll come to a head in March. If it isn't extended, there's talk about extending it now to June. If it isn't extended, it'll come to a head, and a report will be issued by the monitor or the person overseeing the PREPA agency right now. So, but you have a series of debt in Puerto Rico is not just, it's not one debt of the $71 billion. All the public agencies that have about $40 billion in debt, they're all different. All these agencies have different enabling acts. They have different provisions in the acts. Some of these bond contracts have venue provisions, jurisdictional provisions, the shift of venue not only to federal courts, but federal courts in the District of New York, Southern District of New York, some of them. So you have to look at the venue provisions in the bond contracts or bond agreements. And you have to also distinguish between bonds that are insured and bonds that are not insured. Bonds that are earmarked have repayment sources like the sales tax COFINA bonds, and in itself there's 2 or 3 different types of COFINA bonds that have been issued. And you have bonds in Puerto Rico that have full faith and credit. You have general obligations, and you have that are similar, some that are similar to the full faith and credit of the general obligations. So there are different animals out there when you talk about the bonds of the government of Puerto Rico. You have to look at each one, and that creates a problem for purposes of negotiation, because finally what's going to happen here is the bondholders are going to have to realize that they have to negotiate with the government of Puerto Rico in some way and fashion. So someone has to develop a strategy to negotiate the companies that are stressed out, the utilities that are stressed out, which are basically 3 or 4 that we know about, and also the retirement system has to be addressed. So this makes negotiation very difficult unless a system is worked out, a mechanism is worked out. Now, whether the act has served its purpose, yes, it has served a purpose. It already forced bondholders, banks, and even PREPA to the table. It forced the appointment of a person. It gave a breathing spell to PREPA, of course, to the payments that were due last July and August to the banks and to the bondholders. It created a space to negotiate. It brought everybody to the table. Although Judge Besosa's opinion weakens the position of the government of Puerto Rico in some way, the fact that they're going to appeal gives them, in a sense, a second bite at the apple. It's still a threat. The Bankruptcy Act of Puerto Rico, it's still a threat. It still could be reversed by the circuit court. It's still alive, and probably the government did the right thing in a moment of desperation. However, in filing this act, but it never expected the rating agencies and Wall Street to react and the bondholders to react the way they did. It may have cut off more than it could chew, the government of Puerto Rico. Nobody expected the agencies to react the way they did, the ratings to come down so swiftly and so harshly. So there was bad publicity. The junk status of the bond ratings, the market has been closed to Puerto Rico now, and the new issues that are going to have to be issued will require insurance, venue provisions for the U.S. District Court of New York, probably indexed yields, very high rates, and earmarked repayment, very strict earmarked repayment terms, and probably government GO-type full faith and credit, or some sort of guarantee that they will be repaid. So it's been quite a saga. Constitutional history has been made with this case. You're stepping into minefields, really, when you talk about these issues, and we don't know, it's not ended yet. It's still in the process of developing. It's going to take a lot of good faith, a lot of good people together on the table to work out the very serious state of the economy of Puerto Rico. And that's where people should concentrate, not in the courts. This is not going to be solved by the judicial system. This is going to be solved by negotiations. And that's where we should concentrate on. Thank you.